Next case on the docket is JASU Inc. versus Freeman and Associates.
Good morning, Your Honors. My name is Edward Jordan. I represent the appellants in this case, JASU Inc. and JAMIELEIVA. I'd like to reserve 5 minutes for rebuttal, if I may. Okay. Thank you, Your Honor. From the outset, this appeal arises or comes to this court in a framework of Rule 1.380, which is the enforcement mechanism for discovery. Two things or two policies underlining that rule is, number one, is that the rule is not punitive in nature or penal in nature. Rather, it is to effectuate compliance and not to punish the litigant.
Is it your position that the conduct that occurred here did not warrant sanctions, or simply that it wasn't appropriate to sanction the client because the failings were on the part of the lawyer more so than on the part of the client?
Both, Your Honor. Because number one, the conduct which has been complained of was not a violation of any order or discovery request. And then number two, the evidence has established that there was not compliance with orders that were bootstrapped, that the failure to comply or tardy compliance was a result of the attorneys. May I explain?
Please.
Number one, this case arises from a March 21st complaint filed in 2005. No discovery occurs except for by the appellants until October 31st, when the appellees file their request to produce and interrogatories. The appellants then substitute counsel and hire a fellow by the name of Frank Ruggieri, R-U-G-E-R-I. He then requests an additional time to respond to the request to produce, gets an extension, and then files a motion because he has not gotten all of the files from predecessor counsel. Regardless, no answer is timely filed or response to the requests of the appellees, and in February, a motion is filed. The court enters an order on March 3rd of 2006 and says, hey, respond within 10 days. The appellants, as shown in the answers to the interrogatories, on March 13th, signed their answers to interrogatories, but the attorney did not mail anything until the 14th day, 1 day late. I remind the court that it's not punitive in nature. Punishment must fit the crime. There was 1 day late compliance with a court order, but it wasn't by reason of the appellants. Regardless, again, nothing happens until May, when the appellees schedule a deposition not ducus tecum, just scheduling the defendants.
But there's been a request to produce out since October, right? Why do you need to do the deposition ducus tecum? They're already 6 months overdue on the documents, aren't they?
Agree, but the response was, we'll produce it in an ordinary course of business, and the interrogatories were filed. There was some letters going, and the record reflects communications between counsel, where it was agreed that these documents would be produced at what is called Century Management in Claremont, an office. Then there's a letter saying, no, I want the documents in Tavares, Florida. Those letters go to the attorneys. Mr. Leiva or the appellants get new counsel, who is Mr. Lecklum, at this time, which is in June, when there's a discussion of where these documents are going to be produced. Mr. Ruggieri is on his honeymoon, and Mr. Lecklum is in Bermuda on his vacation. That's all in the record. My client has no idea what's going on with the discovery, but an agreement was reached regardless to produce the documents on June 17th between Mr. Lecklem and Appley's attorney. Mr. Lecklem emails from Bermuda to my client saying, and it's in the record, at some point in time you will have to produce the documents. Doesn't tell him when. But regardless, a meeting is set for June 16th, the day before the production is to occur. My client, or the appellants, are prepared to go, and Mr. Lecklem has to cancel that meeting because he has a doctor's appointment. That's in the record. So the documents aren't produced to Mr. Lecklem for his review to produce in accordance with whatever schedule he reached, and my client then reschedules to produce the documents with his counsel. The deposition occurs on the 21st. It's not ducus tecum, and there's an agreement in the record. It's in the appendix on the last page of the transcript, which says, okay, you'll produce the documents on the 26th and will continue your deposition to take it on the documents. On the 26th of June, which is 2 days before a hearing, the appellants appear, bring 8 boxes of documents and plans at Century Management, the place where it was agreed upon. The appellee's lawyer comes in, doesn't complete his search. The record shows, okay, tape up the the boxes, the ones that he requested were tagged. And ultimately, then we have our first hearing on June 28th, where the appellees argue that we've been dodging and hiding and not producing. I remind the court that we responded to the request to produce and the interrogatories within the 10 days, although it was 1 day late by counsel. And number 2, we had already appeared with all the documents on June 26th, and the deposition was not ducus tecum, and we agreed to reschedule our deposition. Bear in mind, we sat for 8 hours in that deposition on the 26th. The court then says, I want you to produce all the documents. Now, this court has found, and it was Judge Sharp that found in the Kilstein matter, that when you say all documents, that's not necessarily an understandable order. It may be subject to interpretation. The testimony is that the appellants understood that to be produce all the documents that were tagged, the ones that they had requested, and they did that by July 7th as ordered.
Did they also produce the 4 boxes that had not been reviewed?
None of those, they did not. They produced the ones that had been tagged plus the plans, Your Honor. And those documents, bear in mind the record is that the appellee's lawyer was to come within 2 days and review those documents. They were always available for his review. They were left at Century Management, taped and sealed. But he did not produce those documents. Nor did he produce any documents with the third-party control. After those documents are produced...
What was that whole third-party control thing?
Judge, specifically on page 23 and 24 of the brief, I've explained to you what those third-party documents would be. They would be such things as construction documents, homeowner association documents, documents of other corporations.
No, I understand what they are. Just explain to me how your client ended up having to provide those.
In the final motion, which was on July, I believe the order was July 31st, but the hearing, I believe, was, and I'm sorry, the date, I don't have the specific date of that hearing. The order was, let me see, the hearing, let's see if I have that order. The hearing was on July 25th, Your Honor, of 2006. And the judge enters his order and says, you will produce all documents, bait stamped and cataloged. Number 1, that's fine, because if you're going to have any privilege, you have to have a privilege log. The bait stamp, that's fine. That way you know what's being produced, because there was questions of what had been produced to that date. But then the judge goes on to say, and I want all the documents from third parties, you'll subpoena them, do whatever you have to do, and get those documents within 20 days. Well, first of all, that requires subpoenas to be issued to third parties, and 20 days may not necessarily cut it, but be that as it may, now the burden has shifted to the appellants to produce third-party documents. May I say, and I don't want to sidetrack, but that's where it came from. But this court has noted, it was Judge Sharp that noted in the Swedinska case, and it's been cited as 702 Southern 2nd 630, where a Polish litigant did not produce documents from Poland. And the court noted that it was the appellees who would then be the appropriate method for getting these third-party documents. Judge Sharp wrote, it would be consistent with justice and fair play for the judge, if he reasonably believes further discovery is available, to require appellants to bear the expense, at least initially, depending on the results of appellee hiring the investigator and traveling to Poland to some such less drastic measures to attempt to solve the dispute. So it would be the appellees to go and get the documents, and if there was any cost, if we had frustrated it, then they would be tacked on at the end of the case. That's what Judge Cobb wrote. But Judge Johnson in Lake County said, wait a second, you produce all the third-party documents. I want them subpoenaed, do whatever you have to do, bait stamped, and you're going to catalog them, etc.
Well, I have completely gotten you off your chronological track, and I apologize for that. But why did he do that?
I believe...
What was it that motivated requiring your client to produce third-party documents?
I believe because what happened in the first hearing in June 26th, where the appellees stated, and I'm quoting from the record, that this is on the 26th of June, on the 28th of June, 2 days after the deposition had occurred, 7 days after the deposition had occurred, and 2 days after we had produced 8 boxes and reams of plans for their review. They argued, and quote, we've been dodging, hiding, and not giving us the documents. The court becomes frustrated because the outstanding requests are from October of 2005. I understand that. The response was filed in March. There are some problems with the attorneys on vacation. They don't get the documents. And then when they're supposed to be produced by new counsel, he gets sick and he can't produce the documents. So now it's another week later. And I think the judge was frustrated. In all fairness, that frustration does not allow him to violate the rules, as noted in the Buckley case, that you can't require one to produce documents not in their possession and control. And so then on June, the order of July 3, which resulted from the June hearing, the court says produce all documents. Subject to interpretation, as this very court has noted, he produces what he understood to be all documents. And there's a conference that he disclosed, an attorney-client privilege in the record, saying, I thought it was all the tag documents. So then when you go to the next hearing, this is what happened during the interim, Your Honor, and this is very important, Judge Griffin, is between the 7th of July, when the appellants literally took the documents personally and delivered them to Tavares personally, because Mr. Leckland was unavailable again. 3 days later, the appellee's lawyer writes a letter saying, you've not produced these documents, under the contention that they existed. But in fact, at the hearing, it was learned, the attorney was Mr. Metcalf, that he just believed these documents may exist but were not produced. So when you go to the July 25th hearing, the court then becomes frustrated because it believes that the documents within their possession have not been produced. However, as noted on page 23 and 24 of my initial brief, the testimony was they were in third parties or did not exist, and some were in fact discarded. That was the testimony as of that day. But the court said, regardless, I want you to produce those third-party documents. A sanction or a rule or an order that is not permitted under the rules. So in answering your question, Judge Palmer, number one, we believe the judge erred by requiring us to do something we could not perform, bootstrapping in the alleged non-production of documents from March, or actually from October.
Were the third parties that they were ordered to get documents from independent, unrelated entities, or were some of them,
Absolutely, Judge.
post corporations, common directors, or any of those sort of things?
Absolutely, Judge. The Blue Heron Estates is the homeowners association. All of the construction documents, surveyors, engineers, pavers, landscapers. The only thing that was alleged not produced, tax returns, but we did produce what we had, and that was so stated. In fact, what's important, Judge Palmer, if I may, and during this interim between the 26th of June and the 25th of July, those two hearings, Mr. Leiva actually gave his attorney 314 more documents that may have related to something. They're called the Sir Speedy Box, and gave them to Mr. Lecklem, who did not ultimately produce them to plaintiff's counsel or appellee's counsel. He did not, he being Mr. Leiva, did not know that. But to make sure that to answer your question, those documents were not in his possession and control, and as a result, subpoenas had to be issued. What happened, and this is where the attorney below for the appellants may have erred or whatever, is he begins communicating with the appellee's lawyer after the July 31st order, which says produce all third-party documents within 20 days. To come up with an agreement of what the subpoenas would be for these third parties. There's some communication back and forth, and there's an email where an extension may have been implied. That's referenced in the brief. Regardless, Mr. Lecklem never served any of the third parties until September 22nd when he got the subpoenas issued. May I retract? He never got the service on the third parties. He only got subpoenas issued to the clerk of the court. He sent them to be issued. Rather than signing his own subpoena, he sent them to the Lake County Clerk of Court to get issued well after the 20 days. And you can understand how frustrated Judge Johnson would be having an order that requires third-party documents, and he just waits until the 22nd to get subpoenas issued. That's when our firm got involved. May I say, starting off in the context of this case, is that the rule is not penal in nature to punish the litigant, but rather to get compliance. When our firm got involved, within 5 days, a deposition had been reset, and all documents bait-stamped, cataloged, and produced were given to the appellees.
And that was all documents at that point, not just tag documents, correct?
Every single document, including...
I'm trying to see where the confusion came from the judge's order in June when he described the documents he wanted copied as every document that's relevant to this case that's been asked for in production. Why doesn't that obviously cover every document covered by the request to produce?
Because when they went on the 26th, 2 days earlier before that hearing, 8 boxes were laid out on a table and plans were done. At 5:30, they come back in and he says, well, I haven't reviewed all the documents. These are the ones I want. An agreement was made to seal those boxes for him to come look at later, and he copied the documents that were requested.
Was there some dispute that they didn't copy everything that was tagged?
There was not. There is not at all, sir. In fact, the testimony was, I think Mr. Metcalf made it a point to take pictures of all the boxes and whatever he had requested. But that is not an issue in this case. In fact, the testimony is that Mr. Leiva, who is the appellant for all purposes, met with his attorney, Mr. Lecklem, outside the courthouse and was told by Mr. Lecklem, his attorney, to produce all the documents that had been tagged and get those to their office because Mr. Lecklem was going to Texas. So any confusion of that order was complied with pursuant to the appellant's knowledge of what was being asked. It was at that point, even if there was a problem, 3 days after, on the 17th of July, it's in the record, the appellant delivered an additional 314 more documents to their own attorney. He, being Mr. Lecklem, did not produce those documents to the appellees until August 18th, I believe. That is not Mr. Leiva's or the appellant's problem. That would be the attorney's problem, but yet we're being punished.
You're down to about a minute and a half.
Understood, but I still have 5 minutes?
No, that's all you got left is a minute.
All right, I'll
and a half.
reserve.
Okay.
Thank you, Your Honor.
May it please the court, Your Honors, counsel. I seem to be listening to a different set of facts than certainly we recall, and I'd like to begin by giving a legal backdrop of where we are. The standard of review here is an abuse of discretion as to the findings of fact made by the trial court. The trial court had 4 separate orders involving the same first request for production and interrogatories. 4 separate orders. Now that amounted to not just 4 hearings, but in the last order, in which the court wrote a 14-page findings of fact and order, there were some 3 or 4 separate sessions with the court where he took evidence and heard the parties and made rulings, specific rulings of findings of fact. I bring that to the court's attention because we're here under an abuse of discretion as to those findings of fact, and remind the court that this appellate court may not substitute its judgment for that of the trial court on findings of factual issues. If reasonable people could differ from the inferences drawn from the evidence, this court is required to view that evidence in the light most favorable to the appellee.
There aren't really any facts in dispute here, are there?
Well, from our perspective, we don't think so. However, the recitation of facts that I just heard are severely incomplete.
Well, they may be incomplete, but I was following along based on the chronology I've got. I didn't hear anything that was false.
Well, let me point to a few things that I think, if not false, certainly would be, at least in my mind, misleading. The discovery requests were made on October 31st of 2005. That would make the deadline for them to become due November 30th, 2005. Counsel for the defendants asked for a 30-day extension, and we, as we always do in professional courtesy, we granted a 30-day extension. 4 days after that 30 days had expired, counsel then asked for and served a request for an additional 15-day extension. In this request, he admits that he is now in possession of prior documents and is prepared to provide responses to the requested discovery, but's in need of additional 15 days. We agreed. We say, okay, fine. So the new due date is January the 18th, 2006. Now, he's admitted he's got what he needs. He's met with the client. He then sends a letter on January 27 to us stating that the discovery responses would be responded to after he meets with the appellants. And that meeting was going to be scheduled within 7 days. So now he's beyond the period that we've agreed to, and he's saying in a letter that's already late, we're going to be late some more by 7 days. This is in January leading into February. This is before we've even had the first hearing in front of the judge. It's important to note that these decisions for delay were unilateral. He didn't call and say, here's what the problem is. I mean, these extensions were granted based on professional courtesy once, twice, and then time would go by and there would be no response. Still no compliance by February 3rd, some 16 days later than the last request for an extension. We felt that we had no choice but to file the first of what would be many motions to compel discovery. We filed this motion. 7 days go by, still no response, or actually several days go by, still no response even after we filed the motion to compel. It was filed on February 3rd. It was March the 3rd, 1 month later, before we could get before the court because of the calendar. So an additional month goes by, still nothing's been produced. The court, in the March 3rd hearing, enters its first order to compel and says we're going to give you 10 more days.
To do what?
To respond to the interrogatories and the request to produce. Okay. We don't make a big deal of it, but it's true that on March the 14th, which was a day late, the interrogatories were served. Clearly not trying to specifically comply with the court's order, but that wasn't the crux of the problem. The problem was they said, we'll give you the documents, but that was all they said. Now,
Did they file a response to the request to produce?
they filed a response and they said they would respond within a mutual agreeable time.
Okay, so they filed the responses.
They filed the response.
Responses 1 day late.
That's right.
Okay.
Now, we then set the deposition of Mr. Leiva for June the 8th, 2006. And this was about the time that Mr. Lecklum had come on board. Mr. Ruggieri was leaving as counsel. We had sent correspondence back and forth saying, you need to give us a time and place because we need to be able to look at the documents prior to the deposition so we can be in preparation for this. June the 8th was cleared with his calendar. Everybody was fine. We're cleared with first counsel's calendar. Mr. Lecklum comes on board and says, I've just been retained in this case. I need you to reschedule the deposition. And we said, look, that'll be fine, but we still haven't gotten our documents. You need to give us the documents. We'll agree to move the deposition until the 21st. June the 6th, Mr. Lecklum emails his client and states, at some point, the relevant documents are going to have to be produced. Now, this is the important thing. In the evidentiary hearing, Mr. Lecklum testified that he requested in writing, by email, and orally on multiple occasions that the appellants provide him with the business records that were responsive to appellee's first request to produce, yet he never received such records from the appellants. It's in the record, volume 15 at 2715. So the appellants themselves, after he'd made several requests, never would give him the documents. And he, in fact, testified in October that he still, to that day, had never gotten the documents.
Is the record established that the client had those records?
The record established that the client had the documents. The client is the one that delivered them eventually to Century Management. The court so found in its order that the client was in possession of those documents and didn't deliver them. June 16th, the documents were to be produced by agreement with counsel so that we could move the deposition date to the 21st. They were going to produce those documents. They never did. June 20th, appellee's counsel, that was us, receives a letter from the appellant's counsel stating that the records were not going to be brought to his office that day. So we get a letter where he's saying they're not going to be brought to my office. Now, counsel says, well, he had to go to the doctor and this and that, but that doesn't stop the appellants from delivering the documents to the office. And in fact, if they were supposed to be delivered to our office on the 16th, why did they wait until the 20th to get them to Mr. Lecklum's office? Now, at that point, we go forward with the June 21st deposition because we're tired of rescheduling, but we don't have documents. Counsel for the appellants makes a big deal about this not being a deposition ducis tecum. This is a party. We don't have to do a ducis tecum. We asked for the documents way back in October. We're entitled to the documents before the deposition. We don't want to take them at the deposition and waste everybody's time. We then have a hearing on a motion, our second motion to compel. The court then enters its order July 3rd and states all documents are to be produced July 7th. Now, it's important to remember at each one of these motion to compel hearings, the appellants were there. They were sitting in front of the judge. The judge looked them in the eye, and in the transcripts of these hearings, the judge said to appellants directly, he says, and I quote, he ordered for all the documents responsive to be submitted within 5 business days. The court went on to state, and I quote, "You understand that, sir?" Mr. Leiva answered the trial court, "Yes, sir." Volume 16 at 16. July 17th, appellants delivered to Lecklum 331 pages of additional documents which both Lecklum and Leyva understood constituted full compliance with the order. That's the statement made in the appellant's brief. It's contradictory to Mr. Lecklum, who's a lawyer and a member of this bar, who testified he never got the documents. He never received them. The appellants, in fact, are the ones, and they admitted, they delivered the documents on July 7th and never gave them to Lecklum. Lecklum said he never even had a copy of them. The documents were not delivered to the appellants until August 18th, 2006, and this is in the appellant's brief. They admit that. And if Mr. Lecklum would have gotten them earlier and we would have gotten them, we wouldn't be here. Then, July 31st, the court enters another specific order regarding the production of documents, because they didn't remember that all means all. They gave some, but not all. So the court says, we want them all, we want them bait stamped, and this is where the third party issue comes in. Leyva's counsel presented to the court, well, we're not in possession or custody or control of some of these documents. And the court inquired, okay, what are we talking about here? Turns out it's his lawyer. Yes, it's the Homeowners Association, but JASU Inc. is the developer and the person in control of the Homeowners Association. It hasn't been turned over to the homeowners. So we're talking about the Homeowners Association, which he controls. He's the developer. We're talking about his lawyer, who has the closing documents. We're talking about records that his agents or closely held companies have, and the judge, as a sanction, certainly has the right to say, as in the Swedinska case, I'm going to make you go get them at your expense. That's perfectly acceptable for a judge to be able to do.
The third parties included a surveying company and a management company, correct?
Yes,
were they tied to the appellant?
These companies are all subcontractors of the developer, and certainly they could have made the request to them. Now, I want to also point to the appellants.
Why couldn't you just subpoena those documents from these third parties? Where's the authority to require somebody else to go subpoena documents from a third party to give them to you when you have the authority to issue the subpoenas yourself?
Well, you're certainly correct, sir, and we could have done that. What this is part and parcel of is the court's third order on our original request, where one of their excuses was, we don't have them. So the court, in order to avoid any confusion, says, as part of this order, as a sanction, I'm going to make you go get them at your expense.
But they never had an obligation to get them from a third party from day one, did they?
Originally, they did not. So this was part of the sanctioning process that the court entered into on its third order and says, you're going to go get these documents. Now, I agree with you, if they're not in the possession, custody, and control under the normal rules of civil procedure, you're absolutely right. But let's cloak this in the fact that this is the third time we've been before the court, and it's acknowledged that the documents that are in their possession, custody, control have not been produced. The court's getting tired of it at this point.
Well, the court may be getting tired of it, but you've got a right to get the court to help you get the documents that you're entitled to. But I'm having trouble understanding why, as a sanction, it's okay for the trial court to order these people to go get documents through third-party subpoenas that they don't have.
Well, this is a minute part of why we are here. Let's remember that they're appealing an order saying that we aren't entitled to attorney's fees. Now, this is the part that's before the court. In fact, the issue of subpoenas to third parties was never even raised in the initial brief in this case. It's the reply brief where he says, oh, that's the problem. But the fact is, every single case cited by the appellants deals with an abuse of discretion where the trial court dismissed with prejudice the action based on the discovery abuses.
And did they get the documents from the third parties and pass them on?
Ultimately, they did.
So they weren't sanctioned, they were not sanctioned by the court or tagged with attorney's fees for failing to get the documents from the third parties pursuant to subpoena?
No, Your Honor. They were tagged with failure to comply with the court's previous orders and ultimately this order for failing to provide the documents in the original request. Remember now, it is July, August before we get the documents in the original request that are part and parcel of the original request to produce. Again, let's think about the sanctions available. Dismissal is not what we're talking about here. I want to remind the court, too, that the rules of discovery, specifically Rule 1.380A, 4, and D, attorney's fees, if the motion is granted, and this is A4, if the motion is granted and after an opportunity for hearing, the court shall require the party or deponent whose conduct necessitated the motion or the party or counsel advising the conduct to pay the moving party the reasonable expenses incurred in obtaining the order that may include attorney's fees. Now, there are some lines of authority which would suggest that attorney's fees are mandatory under that rule because of the word shall. So certainly when the court is looking at this, and I remind you they're in the best vantage point to see the factual history of this case, when they look at this, when the trial court looked at this from its vantage point, it had a number of possibilities. And if you read the court's order, the 14-page order with the findings of fact, the court specifically said there are a couple of mitigating factors, which is the reason I'm not going to deliver the most severe of all sanctions. And the court backed off of that and said, but I am going to require them to pay the attorney's fees associated with these motions. Now that's required in the rule. And so this court, sitting to determine abuse of discretion, should not overturn the factual findings of this court. As a matter of law, there is no de novo issue here. There's no de novo issue that the court has somehow applied the wrong law. The law of discovery abuses is clear. There is a list of sanctions available to us, to the court, and in that list of sanctions, they start out from, you got 10 extra days, to you're going to pay the fines, you're going to pay the cost of discovery, as we saw in the Swedinska case, you're going to pay the attorney's fees associated with the motion, all the way to the very end, which is a dismissal of the case.
Counsel, I'm just not clear about something. We've talked about 2 clumps of discovery, maybe 3 clumps. The first clump is the 8 boxes. The second clump is the third-party discovery.
Right.
Was there stuff other than that you didn't get?
No, Your Honor.
Well, if you got the 8 boxes relatively early on,
we did.
and if you weren't, well, didn't they produce all 8 boxes in a room?
The room, what happened was, Your Honor, the agreement to have them produced came and went. We filed another motion, and then Mr. Leiva took the boxes.
Weren't y'all in a room with all 8 boxes and got half of them reviewed?
Ultimately, we were, yes, Your Honor.
Well, I mean, that was relatively early on, wasn't it?
That was, actually, that was in late June, Your Honor.
It was before the second and third hearings, wasn't it?
It was, no, Your Honor, no, it was after the second hearing that we got a chance to look at the boxes.
Right. So by then, you had all 8 boxes.
But not all the discovery, that's right. Those 8 boxes
okay, well, I am missing something then.
Okay.
We have the clump of the 8 boxes, and we have the third-party discovery. What didn't they provide to you?
We provided to them.
Because you said no, there wasn't anything else.
Well, maybe I misstated it. There were 8 boxes and there were rolls of blueprints that were supplied. It turns out that the 8 boxes and the rolls of blueprints were not all of the documents, and we sent them a deficiency list, which is in the record.
Well, what What didn't you get?
There were things like tax returns and a whole host of other items that we did get eventually.
Were those
in
things
August.
that they contended were in the hands of third parties?
No, ma'am. Those things were, in fact, part of what they had in their custody and control. And their lawyers had some of the closing documents, which they should have been able to provide. The case law will suggest that if your lawyer has the documents, they are in your custody and control. And they didn't come to us until August, after the third hearing on this matter.
What's the date of your letter that details the things that were not supplied, that weren't part of the third-party discovery?
That would have been after the July 7 drop-off of the documents to our office by Mr. Leiva. Mr. Leiva dropped off documents on July 7th, I think it was, and we, on July the 10th, issued a letter at that time to opposing counsel, Mr. Lakelam, and said, here is a deficiency of the items that we believe we didn't get.
That was the July 11 email.
Yes, I think it was, Your Honor.
Okay.
And that wasn't saying we tagged stuff, we saw stuff tagged it and you didn't give it to us. This is, here's other stuff that's within our request to produce that weren't part of the 8 boxes.
That you did not provide us. That is exactly right.
How did you know that if you only got through 4 of the 8 boxes?
Well, what I'm suggesting is that that wasn't part of what was delivered on July 7th, not what might have been in the boxes. Because the judge said at the hearing, I want everything produced on the 7th. Mr. Lakelam was at that hearing, and the judge says, I want them all produced.
But for example, the tax returns that you said they didn't produce until much later.
Right.
Do we know definitively they weren't in the 4 boxes that you hadn't gotten to?
I cannot tell you that, Your Honor. I do not know.
So they brought you 8 boxes, you got 4 of them reviewed, all 8 of them stayed at Century. What was to keep you from just going back to Century and looking at them?
Well, see, that's part of the problem. They didn't all 8 stay at Century. They were wrapped up. Mr. Leiva took them back with him, and they weren't going to let us review them. And we weren't able.
They had revoked their access to them?
Absolutely. We were told we were going to be able to go like a week later, but that wasn't going to be soon enough so that we could be prepared for the depositions. So Mr. Leiva had the documents the whole time, and that's what the court found. The court found he was the one in control of them. He indicated in one of the hearings that, well, no, they were at Century Management. Well, the truth is that he delivered them to Century Management the morning we were supposed to go look at them. So the whole time, Leiva had these documents in his trunk of his car. And so we said, well, you know, wait a minute, we can't go look at the documents when we want to. We've made agreements about it, and, you know, Judge, we need some help here. So that's the factual background of it.
You're way over on your time, so I'm going to cut you.
Thank you, Your Honor. We would respectfully request that you affirm the court below.
I know I have a minute and a half, but if I may,
You got an extra couple of minutes because they ran over by a couple of minutes.
Thank you,
so
Judge
you
Palmer.
can as well.
First of all, counsel said there's not a case involving motions to compel not dealing with dismissal of actions. That's what he said, all the cases cited. And I've cited to you the Buckley case, which is 27433, which came to this court, the Third District Court of Appeal, and that was on a motion to compel documents. Sanctions were levied, fine was levied, and the court reversed it, saying you can't require someone to produce third-party documents down in their possession and control. May I hit what Judge Griffith, what you just talked about with counsel? It is important that the timeline is established in the record because there has been an issue here. The first hearing was dated June 28th of 2006. The 8 documents and plans at that room in Century Management were produced on June 26th, 2 days before the hearing. There is testimony and agreement that they were to review the documents within the next 2 days. Instead, The appellees went to the court on the 28th and said, we want these documents. On the 3rd of July, Judge Johnson says, you're to produce them within 7 days. Mr. Leiva then takes the documents that were tagged and delivers them on or before July 7th. That was the order. I said 7 days and I apologize. The order says on or before July 7th of 2006. He does that. He produces that. All the documents requested that were tagged. The other boxes remained in Century Management. He did not remove those. Those were taped. The agreement was they would stay in Century Management for their review. They never came and reviewed it. Instead, apparently, I guess they were relying on Judge Johnson's ruling. I don't know why.
In other words, the agreement was that they'd go back and finish reviewing them on June 29th, but instead they get the order that was
But the hearing was the 28th.
The hearing was the 28th, the orders entered the 5th, where the judge says, give them all the documents. And so instead of going back and looking at the boxes, they just expected to get a copy of everything that's in the 8 boxes.
Which may not have been relevant because they were produced in the course that they were kept. That's exactly right, Your Honor. Now,
But their understanding of the judge's order was, I don't care if they're relevant, give me a copy of all 8 boxes plus the plans.
Right, and that's not what the order says. Now, secondly,
And was that the whole universe of documents?
Yes,
Or were
it
there
is.
other documents that came to light later, like tax returns?
No, sir. Because what happens is, and if I may, you talk about the sanctions were levied in the last order where there's $42,000 in fees. Remember that this order in July, I think it's dated the 3rd, Your Honor. It may have been docketed the 5th, but I have the 3rd, and I apologize if I'm 2 days off. Okay. But the 1st July order levies a fine for which the appellants had to deliver a check to the appellee's counsel's office. So they paid that fine related to that production. Number 2, when the email on the 11th, as you so appropriately stated, Judge Griffin, that email was sent to the appellant's lawyer, and the testimony is that the appellant contacted Mr. Lecklem, who was in Texas, and said, by the way, you got to get some more documents, and he produced on July 17th 331 pages of documents that may have been related to the request. Now, what's important is that list of deficiency was not known. It was a guesstimate. And so what my client did was say, okay, maybe there's some more. Here's some more documents, because apparently they want these. So the universe had been given to appellant's counsel as of the 17th of July. That's fixed in stone. And that's what the record states. From that point on, the bootstrapping starts occurring, and the hearing in July where we now have to produce third-party documents. May I remind the court, it wasn't, the Homeowners Association is a homeowners association managed by Century Management, a separate corporation that had the documents. Mr. O'Toole, there was an engineer, there were surveyors, and the attorney records were related to the closing attorney. The closing attorney had the closing documents for which we subpoenaed.
Your time's expired.
Thank you,
Counsel.
Judge.
Thank you.
I appreciate your time, and thank you for the extra time as well.